phases of trial advocacy at numerous law schools, including Yale, Rutgers, and Harvard. He's taught here many times at the Attorney General's Advocacy Institute. He's lectured on many, many governmental forums, among those the 1996 Presidential Showcase Seminar of the National Bar Association. He has a weekly radio show. He's a commentator on WOL AM in Washington, D.C. You still doing that, Rob?
Not
anymore.
presently.
Not presently, okay. But he's done that before. And I'm going to turn it over to Robert Tarver.
Thank you. Come on, I paid you better than that to lead the claps. Come on. Louder claps. You want your $5. How's everyone doing today? That's good. I know that I have the group that's after lunch, and I know that that's always the most difficult time to talk to anyone and expect them to retain any information. But we're going to do the best that we can do anyway. I see some of your colleagues, I think some of your colleagues coming in here. Yes, you've been caught. All right. I don't want to start until everyone gets in. Okay. Ever since I was in grade school, I wanted to do that. Where were you? You're late, Mr. Jones. The thing is, when we came in late, we sat in the back of the class. Imagine that, being that comfortable. Things change. Now, you know what? Let's close this door so we don't have to deal with any distractions of any sort. My name is Robert Tarver, and let me ask from the beginning, did all of you get one of the handouts in jury persuasion? I want you to have that now. Who didn't get one? Okay, can I, since you were late, I'm going to designate you to be the person that passes them out.
Fair enough.
Thank you. And before we start, I want you to open up to the first page of that handout, and I want you to read that article. I'm going to give you 2 or 3 minutes to read it. I have to read it comprehensively, but I want you to skim through it. The reason I like to start with this article is that it's I think, a very interesting foundational article. That article is written by Daniel Goldman, and he wrote it for the New York Times. And the interesting thing about that article is it indicates, and I think that there's quite a bit of research that has gone on since then, but it indicates that 1/3 of jurors decide events at the time of initial presentation. Now, the article itself talks a lot about faulty reasoning in how they reach these decisions. And that's something, quite frankly, that we can't do anything about today, right? That's something that, at the very least, any judge who's dealing with a particular courtroom situation has the choice of compelling jurors to be more open-minded, although my suggestion is that doesn't make a difference either. That's not something we can do anything about. But the important thing for our purposes, 1/3 of all jurors decide events at the time of their initial presentation. And what's the initial presentation? Opening arguments. Now, you all did opening statements recently in Keeler and Pruitt, right? Okay. Tell you a little something about these jurors. Now, we all learned, when we learned about the system, that the jurors come in and they sit down and they're open-minded and they listen to people talk to them, and based upon that, they weigh things and they reach a decision, right? That's not the way it works. Not for these jurors, anyway. These jurors become what we call super advocates. In other words, these jurors take a position from the beginning. They listen to one side or the other. They find a story that is seductive. And instead of going into a jury room and discussing that side against the facts, and instead of sitting through a case and listening and being receptive to taking in other facts, they act as super advocates. What do I mean? Well, they then become the attorney in the courtroom, depending on which side they pick. If the prosecution's story is seductive, then they're another prosecutor sitting in the room. And instead of discussing these facts, they sit there and they gather tidbits from what they hear that tend to support whatever their initial conclusion was. Now, that's not unusual for any of, how many of you here are married? All right, you know there's husband and wife arguments. You can look at anything, husband and wife, boyfriend, girlfriend, whatever. You can look at anything and you can draw the information that tends to support your side out of any argument. You know I've done that. I'm sure you have too. That's what these jurors do. That's exactly what they do. They decide based upon a preliminary story and they find facts to back it up. The problem is that just completely ruins the objective nature of the jury process, right? Now, how many of you have tried cases? All right. I'm not telling you anything new, right? You know about these types of jurors, the ones that are intransigent, right? You've heard about these guys. Not only do you know about them, but if you were doing what you should have been doing, you're probably trying to get them to be on the jury when they were predisposed to voting in your favor, right? And so the big game becomes to decide where these people are, who they are, identify them, and co-opt them for your own good. The problem is that people are getting more and more sophisticated as it relates to being able to get around these types of detection methods that are employed not only by attorneys in voir dire, but by jury consultants and anyone else who deals with juries. So we're talking about pretty good pie there, huh? This is also a chance for me to work on my artwork. Talking about one-third of all jurors making up their minds in the beginning. Now, you hear something flapping in the wind? Out of 12 jurors, that's 4 jurors that have already made up their mind. If you don't have their attention, if you don't get their nod, if they don't find you compelling, that's 4 people who are out the window, who are not going to listen to what you have to say later. A 6-person jury, it's 2 people. That could be your whole case. In most cases, that would be your whole case. So what are you going to do? Well, that's what we're here for today. We're going to talk about techniques for going after these types of jurors, going after jurors in general. But specifically, because we have learned that it is so important to reach these people at an early stage, then we have to talk about reaching them. Now, I am talking about substance today, but I'm also talking about style. Now, because we're not being case specific today, I'm talking more about style than substance. I'm talking about technique. And I'm going to suggest some techniques today that you can use to apply to any of your fact patterns, any case that you try at any time, whether it be criminal, civil, whether it be a tax or environmental case, whether it has to do with healthcare, whatever the subject matter is, these techniques will work because they deal with communicating with human beings. Now, I hope that you all intend to, throughout the rest of your career, try cases before human beings, huh? Right? If you do, this stuff is going to be good for you. Now, let's talk about the skills and tools you're going to need to do this. I'm going to ask you to bear with me a little bit because some of this may be a little tedious in the beginning, but it is important foundational material, very important foundational material that I want you to get so that we can move on. So without any further ado, let's try to move on and try to be technically proficient if we can.
Robert Tarver. As a trial attorney, I've made a career of persuading juries. As a television legal analyst, I've done the same thing, only the audience has been different. Instead of persuading juries, I've persuaded millions of Americans, hopefully, to understand my position and to believe in the things I say. What do these two things have in common? Well, the word is persuasion. Today we're going to be discussing techniques of persuading your audience. In this case, we'll be talking about juries. I'll be talking about the tools that I believe it takes to make effective jury presentations and to persuade your audience, which will be juries, to believe that you are credible and you have their interest in mind. Now, there are 5 areas that I hope that we'll be able to cover today. The first of which is discovering and discussing information receivability. And that quite simply is how the brain receives information and how we process information. Understanding this is crucial to understanding how we put together an effective jury presentation. The second item we'll be dealing with is themes. The creation of themes in dealing with juries. Putting forward a theme that a jury can understand and grip as part of your overall presentation. The third area is storytelling. Of course, the role of the attorney as storyteller is legend. We will be talking about, and you will be learning how to put together a story, what the elements of a good story are, what makes a good storyteller. We'll also be talking about the nonverbal cues, how to put together a nonverbal presentation, your stance, your posture before the jury, your gestures, appropriate facial expressions. And last but not least, we'll be talking about fine-tuning your instrument. No, I'm not talking about the trumpet. I'm talking about your voice. The use of voice to convey the feeling and emotion that you want the jury to understand and recognize. At the conclusion, we'll be talking about putting it all together, and I call this the total package. How we meld all these elements into one presentation, one cohesive, persuasive presentation that will convince a jury that you should be listened to. Let's talk a little bit about the first element that we discussed.
Okay, information receivability. That's kind of an awkward phrase, huh? Information receivability. Let's break it down to what it really is. It's how human beings learn and how human beings receive and store information. Very quickly, everything that you do in life, every experience that you've ever had, from the time you're born until the time that you die, our lives are completely written within our brains. You may not remember many things, but it's there, and it's been stored. Now, you may ask what I mean by that. Every life experience that you have, from birth up until right now, makes a filter. And it's through that filter that you process new information. You analyze information. People, all of us, individuals, remember the things that happen to them, right? And if you're real lucky, you not only remember those things, but you learn from the things that happen to you. You learn and you guide your future accordingly. Now, Roger Schenck, who's the director of the Learning Center at Northwestern University, wrote a book called Tell Me a Story, and it deals all with memory, and I would recommend it to anyone. In that book, he says that when you talk about a real definition of intelligence, he puts forth the theory that the definition is really all about understanding what has happened to you in the past well enough to predict when it may happen again. And you say to yourself, wow, that may actually be true when you think about it. To be a successful predictor of future events, and I think you would agree with this, to be a successful predictor of future events, you have to have explained to yourself all the confusing events that you've been through in the past. After you explain to yourself all that confusion, all those confusing events, all those very strange events, the memory of those events, the memory of how you solved them, and the memory of what they mean is then available to help you interpret new events. Now, I'm not talking about anything revolutionary. Let's just use an example. As a young person, you grab a glass and you perhaps pour hot boiling water into the glass. What happens to the glass? It breaks, right? And you know from that point on that that's what happens with hot water in glasses. Now, you've stored that memory. It doesn't mean that you just apply it to hot water in glass. It doesn't mean that you go out the next day and pour it into a glass cup or a glass jar because it's not a glass itself, and therefore it won't happen. No, you've learned. You've learned that glass breaks from heat, a general concept. And every time you employ that, the lesson returns over and over. All of us have been through situations where we see something or we approach a situation that reminds us of something we've been through, right? Haven't we? Okay. We get reminded for a very good reason. And I know this is tough. I just want you to stick with me for another 5 minutes. We get reminded for a very good reason. Reminding is the mind's method for reconciling past events with current events. That's what the memory is all about, reconciling past events with current events. That's what allows us to generalize, speculate, and predict. Some of us do that more than others. And if we do it right, and if we've learned our lesson, it allows us to do it with accuracy. Now, as I said, some people don't do it with accuracy. I have an 18-year-old daughter. She continues to pick bad boyfriends, even though I advise her of the right boyfriends to pick. I'm right. She's wrong. She hasn't learned. But virtually all studies show that we as human beings store up these life experiences in the form of stories. Okay? Now, let's go on a little further. Stories. We use stories to store information. Yes, stories. And all of these stories have elements. And let's call these elements plans, goals, and themes. Now let's assume you're a little boy or a girl and you're watching TV. And it's late, and you see one of those westerns where there's a bank robbery. Here's how that story gets filed. The plan, someone robs a bank. The goal that generates the plan, to get money. The theme that generates the entire goal, to live luxuriously, or to have a better life. Do you understand that? Everyone understand that? How about this one? A man leaves his wife for his younger secretary. All right? We've got the plan. The man leaving his wife. We have a goal that generates the plan. What's the goal? To be with his secretary. And the theme overall that generates the entire movement is to satisfy his needs. All right? Now that's what I made it here. But it could be anything. It could be to feel young again. That could be the theme. It could be any number of things. A person can file all different sets of facts more than once under different themes. And that's consistent with what happens to all of us. Someone tells us a story, and you get something different out of it, right? So, that's the way that works. Our brain indexes catalog these stories according to what they are all about. Brains, of course, have been saturated with stories over and over again. Each one has its own theme, and you've got all these themes running around your head. All the themes are divided as well. And let me tell you, this impulse to put things in story form is so strong that we even create false memory to match the themes that we know about. So you'll get people many times, and you may have done it yourself, believing that something happened in your childhood, believing that, actually there's a woman that worked with me, and she would talk about how strict her father was. Her father used to spank her with the, she talked about the switch and belt and everything like that, and it's, oh, okay, I got spanked with the switch when I was young. Her sister came into work, and her sister, that never happened. That never happened at all. Well, eventually the woman was forced to admit that it never happened. I don't mean as in admission, but in thinking, she was forced to admit that it never happened. And in thinking about how that whole thing was created in her mind, she had become such a strong disciplinarian over the years that she believed that to be the correct way to raise children. And therefore, she believed that she had a happy childhood and was raised correctly. So she created this memory that she had been strongly disciplined. But it just didn't happen. Now, I've taken you all along this route simply to come full circle because I wanted you really to understand that in order to give people the information that they want in the easiest way to have it processed, we need to do it as a story. But not just any old story. It needs to be a thematic story. And when I say a thematic story, I am talking about something somewhat different than this. But we're going to move on off of these topics and get into how we actually do it right now.
Creation of themes. Now this by far should be the easiest part of our exercises here today. And that's because a theme expresses, quite simply, what do you want? You are telling the jury exactly what it is that you want. And so in the case of an automobile accident where someone is killed, you want justice. And so you want this jury to know that I want justice for my client's son who was killed. And so in the case of polluters, corporate polluters who have ruined streams, and you are bringing suit against those polluters, you are telling this jury these greedy polluters have caused so much pain to this community, and by effect, strictly to these jurors as well. You want the jurors to feel and understand the bottom line to this. And everything that you do in your case, everything that you say, and every bit of persuasion will be aimed directly at that theme. You will begin to talk about your theme in jury voir dire. You will begin to talk about your theme in opening statement. You will cross-examine and direct examine along the lines of your theme. And you will close very hard and strong with your theme. Now let's talk a little bit about how theme and information receivability come together. You have in your materials a sheet there called morals. Now you remember we talked about in information receivability how the brain has certain receptors and how there are patterns that have been created over years and years of information being received by that brain. The morals that you have on your list are very interesting because they correspond to the stories that we all know so well. And so, for example, with regard to morals, we find the phrase, birds of a feather flock together. Now, you've heard that before, and I've heard it before. But the phrase takes on special significance in an example that I'm going to give you. I was trying a criminal case at one time as the prosecutor. And the case involved two co-defendants, one of whom we had quite a bit of evidence against, and the other, the evidence was somewhat sparse. But through the use of the sub-theme birds of a feather flock together. We were able to convince the jury that the age-old phrase was true, that because these two young men prior to the crime spent a lot of time together, during the crime were together, and shortly thereafter the crime spent much time together, that birds of a feather do flock together. It made sense. And it made sense because it tripped those information receptors that we talked about when we spoke about information receivability. These moral subtexts are what we call our sub-themes. And as many times as we can put together our theme with these morals, we do a pretty good job of convincing a jury that we are credible in the things that we say. Now let's try a few exercises with these morals.
Okay, before we do that, turn to the morals sheet. Let's talk a little bit about themes. Really about theme. Someone give me a definition of a theme in a case. Oh, please don't make me have to start calling people. Okay. You heard me say in the tape that a theme expresses what you want or what do you want. Theme is actually a lot more than what you want, all right? But it's your wants that form the basis of the theme. From the decision of what you want, you have to clearly look at the underlying lesson of the case. What does this case stand for? What should this case stand for? What do I want the jurors to know about this case? That's what the theme is all about. So, you know about the tobacco company litigation that has gone on and the settlements that they're trying to reach. You're representing a lone plaintiff against Liggett Group. Somebody give me a theme. Theme of the litigation. Go ahead. David and Goliath. David and Goliath. Anyone have any other ones? That's very good. Greed. Okay. I see where you're going with that. Anything else? Greed what? What about greed? Greed is good? The message of the 80s? You know? All right, greed is bad. Go ahead.
What you don't know can kill you.
What you don't know can kill you. Let's go back over these things. David and Goliath. David and Goliath. Why is David and Goliath a good one? Why? Tell me. The underdog, okay? But what is the moral subtext to this whole thing? David wasn't stronger than Goliath, right? David wasn't bigger than Goliath, right? David didn't have 50,000 lawyers sitting at his table, did he? No. But you know what David had? David was right. David's cause was just. And in America, if your cause is just, then 12 people sitting there will decide in your favor. If your cause is just, then you will succeed, then you will win. Oh, what a great theme. God bless America. Great theme. Give me yours again.
What you don't know can kill you.
What you don't know can kill you. Talk to me about it.
Well, usually the theme is not only does the person smoke and got some kind of a disease, but it voluntarily smoked, he's addicted. He didn't know. The theme is the deception the company withheld.
Very good. It's not the fact that you just don't know, but it's the fact that, doggone it, when you go and you buy a product and they put it on the market for every one of us to have, shouldn't it be reputable? Shouldn't I, if I know I'm going in there and buying something that the government says can be on my shelf, shouldn't it be okay? You're telling me my country allows people to sell things that will kill me knowingly? What kind of a place do we live in? No, not my country. Not my drugstore. It has to be some intervening act. And it's those guys who knew all along. And they fooled my government, they fooled my grocer, and they fooled me. Feel it? Do you feel the moral indignation in that whole thing? What we try to do is we try to touch certain nerves, nerves of righteousness, and try to combine them with stories that people are familiar with. Not necessarily the exact story, but the themes of the story that we talked about. Now, are any of you familiar with Jerry Spence? I had the chance to work with Jerry Spence on a number of different news things and had to listen to probably all of 10 stories a day from Jerry Spence. And he tells great stories. But Jerry Spence had a case that he tried. It was the Karen Silkwood case. I don't know how many of you are familiar with the Silkwood case. It involves the release of inherently dangerous materials. The company was called Karen McGee. And Karen McGee was engaging in an inherently dangerous activity. That's the way we speak as lawyers, right? What does that mean, inherently dangerous activity? Escape of nuclear energy from the facility created a danger. Now, you can talk to people and you can talk about inherently dangerous activities without making them feel anything, without making them understand that there is a lesson involved, that there is a theme involved, that there is a subtext involved, that there are morals involved. But that's not what Jerry Spence did. What Jerry Spence did was he simply said in that case that if the lion gets away, Karen McGee must pay. Well, let me go one step further. Jerry also talks about a McDonald's case that he tried. That had to do with an oral contract. And the theme of that case for Jerry was simply, let's put honor back into the handshake. Let's put honor back into the handshake. Those are all themes. Those are all texts. And we're going to come back to those. But, of course, you all know what the granddaddy theme of all is, right? Anybody know about that one? If it doesn't fit, you must have quit, right? Now, that's what a theme will do for you. That's exactly what it'll do for you. Look, I mean, here we are. We're remembering that silly thing. And we've applied it to so many different things. I mean, it applies to clothing. It applies to relationships. You can fit it in. If it doesn't fit, it's got to go. You must have quit, whatever it is. All right? But actually, the genius of the Simpson case was, I think, not even the if it doesn't fit. There was an entire theme that they worked on, which was rush to judgment, obsession to win at any cost. Now, let's go back over these things. We talked about Spence's first one about the lion getting away. If the lion gets away, Karen McGee must pay. In the first example, I think everyone in this room would reason that when people, or people who do dangerous things, should pay when that thing gets out of control, right? Yeah? Okay, all right. No doubt a lesson stored up in your mind somewhere based upon your own prior experiences. You know, you ride the bicycle down the street and little Toto gets out from under the fence and starts yapping at your legs. That's wrong. You're going to keep that dog inside the fence, right? So when Spence talks about it to these jurors, he reminds them of their own experiences with dogs, with cats, with whatever dangerous animal it is, with trees that grow over your side of the fence with your neighbor and you're upset about it, with your neighbor's kids playing on your grass. That things shouldn't happen. They shouldn't get out of bounds. The second example. Let's put honor back into the handshake. A clear reference to a time gone by, right? You remember those times? Who's over 35 here? There's more of you out there, too. You're not fooling me. And that doesn't even count because we had no honor at 35 either. But a clear reference to a time gone by, right? Let's put honor back in the handshake. A time when a man's word was his bond and a handshake was as good as a written contract. Oh, what great days they were. Wouldn't you love to go back to that where you didn't have to worry about whether or not someone's going to keep their word? Wouldn't you want to go back to that? Wasn't that a good time? You don't have to worry about whether somebody's going to be committed. A man said he's going to do something, by golly, he's going to do it. Now, you remember that time, don't you? Don't you? Do you? Who doesn't remember that time? Great. He doesn't remember the time. But you'd like to be there, wouldn't you? And that's the important thing. It doesn't matter whether you remember it or whether you don't remember it. We can all agree that it's a good thing. And so by using those themes, I've created a number of different things. I've created an understanding between myself and the jury with regard to the lion situation. Everyone knows that if you bring a lion on your property, you're responsible if he gets free, right? Is it therefore a big skip, hop, skip, jump to equate a lion with nuclear energy? They're both dangerous. You can only control both of them so much. And God knows if you let either one of them out, you're going to do some terrible damage. It's the same thing. Handshakes. Fairness. And oh, Mr. Cochran, a veiled reference to, reverse reference to the phrase, if the shoe doesn't fit. I kept waiting for the plaintiffs in the civil case to use that one. That's a simple one. No analysis needed there. But let's go on a little further. I talked about rush to judgment. Remember that? Rush to judgment. What is that all about? Does anybody know what that refers to? What significant event that refers to? Oh, anyone? Am I dating myself? Rush to judgment. The Kennedy assassination. Mark Lane. Okay. Let me tell you the story, kids. Mark Lane wrote a book. Mark Lane, very famous author, wrote a book called Rush to Judgment. And it was based upon conspiracy theory in the Kennedy assassination. Very big and important book. And so important, so the phrase rush to judgment became associated basically with the Kennedy assassination. And the reason I had the occasion to speak to Johnny Cochran about this whole thing, the reason they chose this is that they understood that 80% of all Americans believe that some form of conspiracy took place with regard to the Kennedy assassination. Therefore, it's a safe analogy if you want people to believe that there is conspiracy in this particular case. Conspiracy, conspiracy. Rush to judgment. I hope he got a better response. Obviously, he got a better response on that one than I did. Obsession to win at any cost. All of us know someone who's obsessed with winning at any cost, right? Don't we? Now, take a look at your morals list. I'll say from the beginning, this is not about morality. These are not, this list is not about anyone's individual morality. We're talking about story morals. Now, in looking at that, and in considering the material that you had in your Rand case, do you see any phrases that might apply to that case? Any morals?
Far better to bend than to break.
Okay. Far better to break than to bend. Far better to bend than to break. Okay. Work it out for me. What do you mean?
Well, in the Rand case, the officer, instead of just the plaintiff, went too far. Broke her arm.
Okay.
Used too much force.
And so by that you're saying it would have been better for her to work with the person than to have put herself in this position now of basically having broken. Whether or not she's convicted, the fact is that she's gone over the line, a complaint has been signed, and she's in trouble. Okay, anyone else? Go ahead. Ah, you made your bed, now lie in it. Go ahead, work it out for me. Okay, the underlying phrase to that whole thing about you made your bed is, it's your fault, right? It's your fault, isn't it? That's it, yeah, and that works out very well. Okay. Someone has to police the police. Why? Okay. All right. I got you. I'm going to come back to that. I want you to hold that one. Anyone else from the morals list? Okay, how about this? Things are not always as they seem. Hmm? Anyone? You're shaking your head. I'm going to ask you to work that out for me. Yeah.
Just the whole perception that possibly she was drunk and disorientated, that's why she came off the ramp, whereas she truly may have just been lost. You know, the fact that she feared that she was drunk and violating the law by going up to the barricade, it truly may be the fact that she was lost.
Right. Very good. And in fact, isn't that the reason why we try cases for the most part? Because things are not as they seem. I think it is, either in a complaint or an indictment. How about there's no believing a liar even when he speaks the truth? Anyone see that in here? Go ahead. You shake your head, I'm going to pick you.
Well, the plaintiff in this case, pretty clear. I think actually both ways. Plaintiff in this case lies early on in terms of talking to the officer, talking to the first officer, and then why should we believe the story that she tells?
Very good. Very good. Very good. It's a very good match. Okay. Did you do your opening statements yesterday, any of you? All right. As part of your statements, did any of you adopt themes? Let me hear some of your themes. In which case? Work it out for me.
That the selected official states in the deposition that once he saw the candidates interviewed on the 25th, that presumably was based on the race of the candidates, not what was inside their book, meaning their credentials,
Right.
their accomplishments.
Very good. Very good. Go ahead.
A bully with a badge.
Bully with a
Bullies
badge.
have something in common, or a few things in common.
And what are they?
They have some type of authority, either through a badge, a uniform, or physical size, or a weapon, or a stick. They also have poor judgment in common. All bullies have poor judgment. They use that authority to bully people around, to make people do things that they shouldn't have to do. What we have here is a situation where we have a police officer who has earned respect and should be respected by the people of the country, where this person used poor judgment in her police technique and her police procedures and bullied the plaintiff.
Okay, is this kind of a modified David and Goliath type situation? Someone who has all the power and control in a given situation against someone who has little or no power and control? Would you say? I mean, it might not be. I'm just throwing that out there. Okay. Anyone else? Opening statements. What'd you do? Yes, sir.
Actions speak louder than words for a case. I think it's
Okay, very straightforward and to the point, right? Actions speak louder than words. We don't want to see what you have to say. We want to see what you've done, right? And it's a very clear indicator, and that's something that rings with everyone. The fact of the matter is that you will continue as you go along in your career as trial attorneys to select themes for these cases. You'll do it unwittingly many times. I'm suggesting that you now want to begin to do all of your theme selection very willingly, very understandingly, and you want to modify your entire presentation and your case based upon the theme that you select. It is very important that you present jurors with, as we talked about before, a seductive story. You can't make a seductive story if you don't have the blueprint for a seductive story. What is a seductive story? Well, number one, a seductive story is a story that holds to its original theme. Number two, it is a story that makes sense. It rings true. And number three, beyond the fact that it makes sense, it is compelling. Compelling. Now, I can tell you factually what I had for lunch today. And, is there anybody here doesn't like pizza? You guys like pizza. You know, I could sit here and I can describe, you know, I had a cheese pizza, a little cheese on the top, tomato sauce. It was hot, crust was thick, little pepperoni on top. Do you want that? Did I make you want that? Is that compelling to anyone? It's not compelling. What I'm suggesting at this point is that once you have the theme, once you create the theme, you then have to sell that theme. You've got to make it compelling. The story can be compelling by itself, just like pizza can be compelling by itself. But you know what? If I tell you about a pizza, you can't smell it. And it's the nature of the pizza itself that makes it compelling. Your description has to match the nature of the object or the scene itself. So what we're going to talk about now is how to actually present compelling stories so that people are compelled to understand and accept the things that you say. And hopefully, after this break, we'll get a chance to talk about that part. All right, I'm going to give you a chance to take 10 minutes, if you would.
Once upon a time, in a faraway land, there was a tiny kingdom. Peaceful, prosperous, and rich in romance and tradition. Here in a stately chateau, there lived a widowed gentleman and his little daughter, Cinderella. Although he was a kind and devoted father and gave his beloved child every luxury and comfort, still, he felt she needed a mother's care. And so he married again, choosing for his second wife a woman of good family with two daughters just Cinderella's age, by name Anastasia and Drizella. It was upon the untimely death of this good man, however, that the stepmother's true nature was revealed. Cold, cruel, and bitterly jealous of Cinderella's charm and beauty, she was grimly determined to forward the interests of her own two awkward daughters.
Storytelling is perhaps the most important part of jury persuasion. Human beings are, of course, storytelling animals. We tell stories all the time to recreate our life experiences. The old people tell stories to young people about how things used to be, and young people, of course, tell all kinds of stories to adults about anything when they want to get over. The trial lawyer must be a successful storyteller, and he must use his storytelling ability to conjure up the image that he needs to portray to this jury. The tools of the trial attorney are words, and the tone of voice is used to communicate what the trial attorney wants to get across to that jury. As we listen to the story of Cinderella, and as we listen to the storyteller here, we are aware and reminded of the storytelling of our youth. And that's the purpose of storytelling, to bring us back to, as we said before, information receivability. It is no secret, and we all understand, that human beings best receive information when it's put in story form. And therefore, the trial attorney must take advantage of this. Now let's listen again to Cinderella, critically if we can, paying strict attention to the language that the storyteller is using. Listen, if you will, to the phrasing that the storyteller uses. Simple phrases, simple words. Listen to the description that those words convey.
Imagine listening to Cinderella critically. But I do want you to, and I don't usually stop here, but I want you to listen in particular to the description of the stepsisters and how she makes the transition from the descriptions of what's going on with Cinderella to the entire story of the stepmother and stepsisters. If I can get it going.
Once upon a time, in a faraway land, there was a tiny kingdom. Peaceful, prosperous, and rich in romance and tradition. Here in a stately chateau, there lived a widowed gentleman and his little daughter, Cinderella. Although he was a kind and devoted father and gave his beloved child every luxury and comfort, still he felt she needed a mother's care. And so he married again, choosing for his second wife a woman of good family with two daughters just Cinderella's age, by name Anastasia and Drizella. It was upon the untimely death of this good man, however, that the stepmother's true nature was revealed. Cold, cruel, and bitterly jealous of Cinderella's charm and beauty, she was grimly determined to forward the interests of her own two awkward daughters.
Awkward, cold, cruel, awkward. Oh, now what did I do with the lights? Oh well. You'll just have to be in the dark about some things. Mark Twain once said that it's a mighty poor storyteller that can't tell it better than it actually happened. That's exactly what we're going to be talking about. Telling a story. Thanks. Yeah, there we go. I couldn't figure out how it worked. Now, don't you love a good storyteller? Everybody, I think, has this one friend. I have this one friend. Tells fantastic stories. He worked at a club in the summer at a resort. And he would come back every weekend. He'd sit us down. Guess what happened to me this week? You're not going to believe what happened to me. Sit down. I got to tell you this story. And we would sit there and we'd be captivated. We would listen. Hours and hours. Listen to what he had to say. One drink. Listen to what he's talking about. Everybody has a friend like that. And why do you like to listen to those people? Well, you like to listen to those people because they don't just tell you a story, but they bring you along with them. They rope you into that whole activity. Conversely, I think everybody also has that one friend, you know, that one friend that can't tell a story but always tries to. And about midway through his story, you look for excuses to turn to somebody else. And it always happens. He ends up getting cut off. Storytelling is an art. And to be, I believe, a good trial attorney, you have to be a good storyteller. As a storyteller, you are not an objective reporter of the facts. You know, this is not a just the facts, ma'am situation. No, you're an advocate. You're an advocate for your position. Storytelling, as I said, transports us into other worlds and into other lives. Now, this is important because you have to understand that your juror is sitting there in a very clinical position. He wasn't at the scene of the offense. He didn't see what happened during this crime or offense or this set of facts. He didn't participate in whatever scheme or plan that you say happened. That's what you say happened. And he doesn't know the people or the personalities involved. It is completely up to you, each one of you, to show him, to make him see, to make him feel, and to make him understand. And in order to do that, he has to visualize it. He's got to see it. How do you do that? How do we do that? Visualization. Unless the storyteller can make the juror see what has happened with his words, see what he wants them to see with his words, unless he can use words to paint a picture to the jury, it's just a mere exercise in reciting words. Remember the pizza? Just reciting words. You didn't taste that. You didn't smell it. You didn't even want it. But if you can create in their minds a moving picture, a picture of action, with each scene materializing as you tell it, then for that juror or for that individual, memorizing that whole scene that happened that you talked about is superfluous. They will understand it. They will recite it. It will become a part of them. Gesture and conveyed feeling become natural. The attorney and the jury become one, just like the storyteller of Cinderella became one with you. How do we do that? How do we make people visualize? Well, we do it through language. And the cornerstone of language, words. Say, why is this guy putting all this simplistic stuff on this board for me? The reason I'm doing it, I'm putting simplistic stuff, and it is simplistic stuff, is that we as attorneys have to deconstruct. We've got to begin to break down a lot of what we believe makes good trial attorneys.
Patrick Conley. Come and see.
Words, of course, are the paint that we use to paint the picture. They should be as colorful as whatever the situation we're talking about allows. You use enough description in your words to let jurors visualize and see what you're talking about without over-describing, without taking them completely into it. Remember the story of Cinderella? I asked you to pay attention to those words. Cold, cruel. Now, she could have described, we all know what those stepdaughters were like, right? You know, I mean, they were witches. They were horrible. They were mean, they were ugly, they were all kinds of things. But what does she say? Her own awkward daughters. Understatement. Understatement. Cold, cruel. If I said to you, it's cold and cruel, that doesn't get it. Cold, cruel. Simple words. Words are very, very important. Let me give you an example. Police officer goes out on the street, makes a drug bust, grabs the guy, collars him, puts cuffs on him, drags him into the station, up to the booking desk, Says, Joe, I just caught this guy selling cocaine. Charge him with whatever. I just saw him on the street. I watched the whole thing. Hand-to-hand transaction. One buy. 6 months later, that same police officer walks into a court of law, puts his hand on a Bible, sits in front of 12 people he doesn't know, and that same activity that he just described before sounds something like this. Well, I apprehended the subject after the observation of a hand-to-hand narcotics transaction, and in his possession was a glassine envelope which I determined would be cocaine. What's that all about? Didn't you understand it the first time when he said to Joe, I just busted this guy? I just arrested this guy? What is all that gobbledygook? Now that's police officers. But lawyers are no better. You guys are no better by any means, right? Lawyers are actually the worst. The lawyer stands up in front of you. He says, ladies and gentlemen of the jury, I submit that you can reasonably find. What is that all about? What does that mean? Who's he talking to there? I mean, would he talk to his mother like that? Huh? No. It would be, Mom, I think you're going to see it my way. Well, why should you talk any different to these 12 people than you talk to someone who you know? Someone who's a friend? Someone who you care about believes what you say? I'm suggesting that you shouldn't. Mom, I think you'll see it this way. Ladies and gentlemen of the jury, I suggest you see it this way. I think you'll see it this way. I think that this means whatever. Let me tell you what I think. Let me tell you what this means. He did this. Deconstruct. Break down the language. Speak like a friend, not like a lawyer. Speaking like a lawyer scares people. You use sensory words wherever possible. Remember the 5 senses? Sight, glowing red, gleaming. Hearing, shriek, blasting. Smell, burning, rotten. Heavenly, savory. Taste, bitter, salty. Touch, sharp, plush. This is the type of language we use when we're talking to our families. This is what we say when we really want people to understand what we're talking about. And yet we leave it outside of the courtroom all the time. And I'm suggesting that this is what you want to do with your jurors. Now, if you ladies in here, does anyone have a child under the age of 7? Does anyone have any children at all? I need one of the women. Okay. How old is yours?
No, 25. I'm way over here.
No, there's someone in the back here that I was... How many?
2.
How old? 15, 17? Okay, you have... 4. I'm not going to bother you. How old?
11, 9, 6, and almost.
6 and 4, okay. Would you come up for me, please? I want you to do something, if you would. I want you, for our purposes here today, would you describe, you have a child that's been in daycare?
Well, they have a nanny.
They have a nanny?
Yeah.
Okay. Were you at home with them at one point?
6 years.
Okay. And then you had to leave and go to work?
Right.
Okay. You remember the first day that you did that?
Yes.
Talk to us about the first day that you did that.
The first day I came to work, I was very excited about having an opportunity to return to the practice of law in the environment division. I missed my kids. And I remember, after a nice morning of introductions around the office and going to lunch with some of my compatriots, that I
I very much wanted to go to the Department of Justice store to buy them all T-shirts and sweatshirts of the Department of Justice.
What did you miss about your kids?
What did I miss? I missed, for one thing, in the longer term, the personal interaction with human beings, and to some extent the nonverbal communications.
Describe the personal interaction
Well,
between you and your kids.
yeah, as much as I like people in the office, I don't hug them. I never kiss them.
What's a hug feel like from one of your kids?
Great. They are great huggers.
Yeah.
Children have,
They grab you around the neck there.
have the capacity to show that love in ways that we don't relearn until we're older again.
Yeah.
And they do it so spontaneously that it's really wonderful.
What's it feel like to you when you get hugged?
Deep satisfaction.
What kind of satisfaction? Happy?
Happiness.
Does that give you any physical feeling? Warm, fuzzy?
Warm fuzzies.
Yeah.
That's where warm fuzzy expression came from, I think.
Okay, all right, thank you. Give her a hand. Let me tell you what we're doing here. Let me tell you why I brought her up. I brought her up because, number one, I wanted to do an exercise in storytelling. She was telling you the story of what happened on her first day very briefly, and the sequence of how it happened. But more importantly, what I want everyone to understand is that it is natural for all of us when we're talking to people that we don't know to speak in harder, colder terms than we do with our friends. Now, if you listen, she talked about the people she worked with, and she talked about, well, let's go from the last parts that you talked about. When you talked about the interaction with your child, and you were talking about types of love, and you were using very, very tight language, which we understood, I believe. I think everyone understood, right? But I'm suggesting that in most cases, you might not talk to your friends like that. You might be a little more loose with your friends in describing, what you feel about your children. They're great. They're absolutely wonderful. Hugging them is like, whatever, that type of thing. And that's what I was trying to draw out of you. What does a hug feel like? We talked about what was going on, that you were getting affection. I think you termed it as affection. And I asked you, what does that mean? Hug? That's what we want to get used to do. We want to get used to breaking those things down and talking about the more fundamental things of what we mean. If we're talking about hugs, let's say hugs. You know why? Because I know what that hug feels like. I've got 6 kids at home. I know what that's like. And when you started to talk about the affection, you should have seen the smiles that came out around here. And that's because everyone here has their own experience, and they're processing it based upon what you say. Now, if you really start to describe it warmly, then they're going to feel, as opposed to just get a part of it. They're going to feel. The more you describe it, the more you bond that with them, the more they're going to feel, and the more they're going to understand, the more credible your story is, even if it's a story amongst friends. And so that's what we want to begin to do, to begin to break down those hard, cold narratives that we all speak in. When she told her story, as I said before, many of you thought about the first day away from your children. That's what it's all about, making people understand. Put words together in shorter sentences. It was a great hug. He's a great child. He's a good boy. Wonderful boy. Those types of things. Deconstruct, as I said. Now, you also want to be able to create distinction amongst different characters and individuals. As I said before, your jurors don't know these people, but the character traits of individuals can be made very apparent through face, voice, and body movement. Now, let me have a volunteer, somebody, just anyone. You had your hand up, sir? You. No, you. You had your hand up. Oh, I thought it was your hand pointing at yourself. I was confused. It's probably the only time in life it's ever going to work. You know? Okay. Now, I want you to face them. Just stand and face them. And I'm going to tell you a little something about your friend Bob Johnson. When you were sick, Bob Johnson stood by you. When your house was going into foreclosure, Bob Johnson went with you to the bank and made sure that you got a loan. Bob Johnson has always been good to you. Bob Johnson is a man of the highest integrity. As far as you're concerned, it's just right up there, a little bit lower than God. It's Bob Johnson. Because he's been good to you. And you've seen the things he's done in the community. He's helped people. He's taken care of sick people. He's brought puppies into his home. He's done all different types of things. Now, I want you to say this phrase: Bob Johnson, an honest man. And I want you to talk to them, and I want you to say it like he's the most honest person that you know.
Bob Johnson, an honest man.
Okay. Come on up. Thank you. I'm going to use a few of you. Come on up. You had your hand up. Come on. Okay. Same thing. You know what Bob Johnson's done for you and your family. You know Bob Johnson's always been there. He's an honest man, right?
No.
Tell these people. Bob Johnson, an honest man.
Bob Johnson is a really honest guy. He's a great guy.
All right. One more person. One more person that wants to tell me about Bob Johnson. Come on, after what Bob Johnson's done for you? You ingrates? Come on up here. Ingrates. Oh, my goodness. It's a good thing it's not me and it's Bob Johnson. I wouldn't do anything for you. He's an honest man. Tell them.
Bob Johnson, an honest man.
Okay. All right. Did you see that? Did you see all three of them? The way they did it? Each of them in their own way. But there was the sincerity, and I hope you didn't miss this. Did you see how they had a hard time, each of them, keeping that hand from coming up? Did you see that? They wanted to open those hands and say, an honest man. He opened his. She opened hers. He fought it as best as he could, keeping it up there. But see, there's an openness involved when you want someone to understand something. And particularly when you want someone to understand something that's sensitive. Bob Johnson, an honest man. Now, did you also hear where the emphasis was? What word? Honest. Honest. You wanted these people to believe that he's an honest man. That's the important part of that sentence. Now, I need you. Yes. Turn around and face these people. Bob Johnson, nasty scoundrel politician that he is, has been caught on tape taking bribes to allow raw sewage to run next to daycare centers. He's reprehensible, this Bob Johnson. He's a lizard. In fact, Bob Johnson is the one that's responsible for the 200% rise in your property taxes, just so he could pad his own coffers for his re-election. He's proclaimed himself to be senator for life. He's never going to get out of there. In fact, your son will probably be living with this same vile senator years from now. He's evil. He kicks old ladies. He wouldn't take a puppy into his home. Now, talk to them, saying the same phrase, Bob Johnson, an honest man. Let them know how honest you think Bob Johnson is.
Bob Johnson, an honest man.
Okay, give me one other person. One other person. We just need one more. I understand you're not standing up for Bob. You, sir. Yes. Same vile Bob. You don't have to stand up there. Same vile Bob Johnson. Same nasty character scoundrel.
Bob
Caught.
Johnson, an honest man?
Okay, very good. Very good. Now, do you see the two deliveries? Him first. How would you describe that? Sarcastic, right? Everyone says the same thing at the same time. Sarcastic. Sneering. Any of you believe that Bob Johnson's an honest man based upon what he said? Of course not. The same thing with this gentleman. Which simply goes to say that you can say the same phrase many different ways. And each of the ways that you say it can convey a completely different meaning. Which goes to say that it's not so much of what you say, it's how you say it. And we're talking about using words, phrases, language to characterize, to describe. Words, again, are the paint for your picture. And so you've got to be very careful with how you use them. You can't try a child homicide case and be upbeat. It's not natural. It doesn't fit. You can't try a healthcare fraud case of small proportions and act like it's a capital case. Jurors are watching not just what you say, but how you say it. Now, I want to move on because we're running slow on time here.
Nonverbal communication is essential. Now, this is the part of our programming that most blends together the skills of television with the skills of trial advocacy. Now, think about the television personalities whom you admire. Particularly, think of the anchorman. What is it about them that you do admire? Number one, you tend to trust them. But why do we develop this trust in these figures? We don't know them, but we feel like we do. Part of the reason we feel like we do is because of the nonverbal communication skills that they exhibit on a daily basis on our television screens. Now, one of the things we have to understand is that within the first 15 minutes as trial attorneys, jurors have made decisions about us. They have made the primary decision, one of the most important decisions, which is whether or not they like us. Now, I'm going to use this phrase now, and I want you to hold on to it. It's likability. You give a jury 4 choices when you first stand up before them. The first choice is that they can like you. The second choice is that they can dislike you. The third choice is that they can be neutral or really not care at all about you either way. And the fourth choice is that they can feel sorry for you. Let's deal with the first choice, like you. This, of course, is the preferable one, and I don't think that requires rocket science, of course, to figure that out. If a jury does like you, they may not like your message. They may not like what you have to say, but at least they will hear what you have to say. And that's most important, that you give yourself a chance to be heard by the jury. If they dislike you, or if they feel neutral about you, that click button goes into the off position. They turn you off, and they just don't listen at all. Now, if they feel sorry for you, they may not listen to you, but there's always a chance they may give your client a break simply because they feel sorry for him, too, for having you. All in all, these are the points of nonverbal communication. Now, I'd like you to remember these 4 keys to communication. The first is the mind. Now, the mind refers to the message that you give to jurors, the verbal message, the intellect that you use. The second is the face. The third is the body. And the fourth is the voice. Now, I've mentioned those three together because those three refer to style. The first refers to message, and the second three refer to style. Now, sadly, these days, style has become almost as important as message. And that's unfortunate. But when we're dealing with nonverbal cues, what we want to do is to compensate and to make sure that our style is right up there with the message. Now, as I mentioned before, in the first 20 seconds of your being in front of a jury, they will make decisions about you. And they'll make decisions about you based upon your style. Now, let's deal with some of the elements of style. To begin with, the face. God has given all of us the tools that we need to be able to engender a warm and fuzzy feeling with jurors. And that is, number one, our smile, and number two, our eye contact. Now let's first deal with the smile. A smile is a good thing. We're the only creatures, I believe, on the face of this earth that can smile. And the smile, as we said, engenders warm feelings. But you've got to be very careful when using a smile in the courtroom. Number one, it must always be appropriate. Number two, it must always be genuine. If either one of those two elements is missing, then you shouldn't use it at all. Eye contact is a crucial part of nonverbal communication. You know, it's said that the eyes are the mirror to the soul. And what you want to do is you want to show jurors that you're bearing your soul to them. Looking a man or a woman directly in the eye shows that you have confidence in your case and that you have a message that you want to convey directly to that person. Eye-to-eye contact lets a person feel like you're bonding with them and that you're conveying important information that is for them only. Now, when we talk about maintaining eye contact with a jury, one of the things you must be very clear on is that eye contact should not be uncomfortable. In other words, it's said that the longest glance to any one juror should be no more than 3 seconds. And you can feel free to look at any number of jurors in the jury box. In fact, you should look at different jurors in the jury box. You shouldn't just bond with one. Now, I want to add this at this point, and that is that there's another part of nonverbal communication that goes hand in hand with eye contact, and that is the pause. And when I talk about the pause, most of you think I'm talking about that space between two particular thoughts where nothing is said. All of us would basically agree that that's what a pause is. However, how many times have you heard when people are speaking and they get to the end of one thought? They begin with or something of that nature, bridging to the next thought. That's not a pause. When I say pause, I'm talking about a complete stop. Just like there was a stop sign there, come to a complete stop, give it a space, and move on to the next thought afterward. Well, why is that important? Well, number one, it gives you a chance to think of what your next thought is going to be. It gives you a chance to put together in your mind the next thing that follows in your argument. But equally important, it also allows jurors to know that you have finished your thought, and it gives them a chance to absorb exactly what that thought was and to fit it into the sequence of important events. And that's crucial. So the pause and eye contact go hand in hand. Now, moving forward from this point, there's another area of nonverbal communication that we should deal with at this point, and that is the facial expression. Remember, we talked about the face. There are 3 facial expressions that you should be aware of. Everything you do in that courtroom conveys a message, and the way that you carry your face is no different. We have what's called a closed face, and that, to demonstrate it, would be like this. The vertical lines across the top of the eyebrows, the eyes slanted down in a somewhat angry look. Then there's the neutral face. And the neutral face is a masking face. The neutral face says, I feel nothing, I hear nothing, I see nothing, I'm just here. And we have, lastly, what I think is the preferable face for most of the occasions that you will face in the courtroom, and that's the open face. Now, the open face is one that we see used quite often in television by television professionals. In fact, it's taught by broadcast professionals, and that is that the eyebrows are elevated somewhat over the eyes, that you maintain an open expression without a smile. The easiest way to describe how this expression is attained is to picture yourself coming upon a baby in a crib. Even the hardest faces that I've seen in coming upon and approaching a baby in a crib will immediately shift to an open face. Eyebrows raised. That is the open face. That's the preferable face.
Okay, a little about nonverbals. Much of that is self-explanatory. You can tell a very good story, but you need nonverbals to go along with it. I talked before about how all the mechanics need to be put together, about appropriate gestures, about movements, about smiling, about all those things. They all come together when you're telling your story in an appropriate fashion. You want to have what we call appropriate affect. Now, with that in mind, let's talk about these nonverbals. The closed face. We're talking about how you hold your face. Personally, I had a tendency to keep a closed face when I was a younger attorney. You know, I was always walking around like this, and I really think, looking back, that I scared some people into verdicts, you know, a few times, because I was looking so mean. And then what was I mean about? Closed face. Closed face is not appropriate. Closed face prevents, or closed face shows tension, and tension prevents dialogue. The last thing you want to do is to close yourself off from your audience. And that face makes people think that you're angry. And people don't want to hear from someone who's angry all the time. Now, having said that, there is an appropriate time to display anger. You just have to know what it is, and I can't tell you what it is. But it certainly is not all the way through a case, as I was doing. The neutral face. What's the neutral face? That's the face of all lawyers. That's most of your faces when you're trying cases. You know, that's, you stand up in front of the jurors. May it please the court, ladies and gentlemen of the jury, I represent the Commonwealth in this action, da 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 da. God forbid that you show anyone that you're alive. God forbid that you show anyone that you have any fire for this case. We just don't do it. Nobody can bond with that face. You can't get anything out of that face when you look at it. And I think I know why we do it. We do it because that's what we think that lawyers are supposed to do. That's what they do on television. That's what they used to do on television. But the open face is the most important tool we have. The face that says, hello, I'm ready to engage you in conversation. I'm ready to engage with you. I'm ready to talk with you. I'm ready to impart information. Now, let's try it. Let me see from all of you the open face that we describe. Eyebrows slightly raised. No, that's scary stuff. Eyebrows slightly raised. It's an engaging face. I'm ready to engage you. I'm ready to talk. I'm ready to be here. I'm ready to give you a message. Come on, let's see it. Oh, no, this is not working. Okay, that's not working. Let's do the baby demo. Imagine yourselves walking up to a crib, seeing the baby in front of you. I want you to look at the baby. Go on, look down. That's the best way to do it. Look down at the baby. And on the count of 3, I want you to all say, "Hi, baby." See the baby. You have to see him, okay? It's a cute little thing. 1, 2, 3. Hi, baby. Okay. Now, you see, do that one more time. 1, 2, 3.
Hi, baby.
Oh, no, so you see I'm watching. That's why. As I said before, even the hardest people, even the most difficult cases, cannot resist the baby. Your face will immediately change. When you feel yourself getting stonewalled, when you feel yourself developing either that closed face or that neutral face, use that exercise. Use it. Now, you don't have to smile. That's not the point. The point is that when you come to that baby, it's, "Hi, baby." And "hi, baby" always works. It's always worked for me. No, not that "hi, baby." That's "hi, baby." I'm talking about "hi, baby," okay? See? Yeah. That's not what I'm talking about. Eye contact, all right? We talked about eye contact in there, and as we said, you don't want to look at people for too long. It makes them uncomfortable. And I've seen some attorneys where they feel like they have one person in the jury that's their advocate, and they will stare that person down. I mean, I thought that one time when I was trying one case. One person I thought was my advocate, she would come out of the jury room and she would, give me nods and everything. And it was time for the verdict. She came back in, and as she came through the room, she gave me that, and they proceeded to convict my client. And I looked back at her, and she, leaving the courtroom, she was, why are you acknowledging me? I completely misread those signals, completely misread them. So you may be misreading some of the things that are going on with the jurors. They may be uncomfortable. Now, I talked about pausing before, and this is very important because using a pause in conjunction with eye contact is an art. You want to maintain eye contact with your jury. You want to always be looking at them and not looking at your notes. The convenient place to look at your notes is when you stop making eye contact. And that's at the conclusion of whatever your thought is. When you conclude one thought, you stop, you pause, you go look at your notes. That's when you look away. You give the jury time to absorb what you've said. Why is that important? Well, the worst thing as a persuader is to look away from jurors to your notes while you're talking. Lawyers are the worst at this. They're absolutely the worst at this. They walk around and they talk to jurors, and if you're the jury, they'll be talking, and they'll be looking around, always looking like they're either looking for pennies from heaven or looking for whatever, all over the place except for the jurors. Why is that? Why is that? It's rude. It's distracting, and you shouldn't do it. The reason we do that as lawyers is that we've seen it on television. All good lawyers do that. Perry Mason did that. We've got to stop that. The key to appropriate face and body coordination is that it must be natural. And those things that I just did there, those types of behaviors, walking around with your head down, looking like you're trying to kill cockroaches or something like that, or head up, that's learned behavior. That's not natural. You don't do that with your friends. You don't do that with your mother. When, as I said, with natural behavior, when you're describing a sad situation, let it be sad. Let your voice show it. If you're talking about, for goodness sake, if you're talking about death and destruction, if you're talking about pain, if you're talking about murder and mayhem, there's absolutely no reason why you cannot be indignant. There's absolutely no reason why you cannot be sad. If you're talking about a tort where someone has lost their father, and the 3 sons sit there, not knowing what it's like to have a father. Every minute of every second, of every day, of every week, of every month, of every year for the rest of their lives, without a captain at the helm of their ship. And why? Because some kid, a ruthless act, decided that he was going to remove a stop sign, a childish prank, was going to take a stop sign down, take it to his college room. Oh, it was funny at the time. These three boys laughing. They're not. And you want the jury to know that they're not laughing. You want to convey that. And your voice can do that. Now, I don't know how many cases most of you have tried, but to be caught in a courtroom with a monotone-voiced attorney is tantamount to being banished to hell. I mean, it's like nails on a blackboard to listen to someone just say whatever it is over and over again and not stop in an opening statement. Conversely, it's also just as bad to listen to someone who, at the end of their sentences, always decides that they're going to go up. And so you just wait for that person to go up to signal the end of the sentence, but you really don't hear what he's saying. You've got to be very careful of that. Very careful. Likewise, you don't need to blow people away. All right? And I've had a strong voice for a long time, and sometimes you feel the need to blow people away. It's wrong. You have to remain naturally vocal. Now, that's not to say that you cannot change your voice infraction, but it needs to be natural. It needs to be natural. And let me tell you this, if you really want people to listen, just like it was said in the commercial, if you want people to listen, probably the best way to do it is by a whisper. And not a whisper all the time. You've got to be able to change. You've got to be able to go up at 1 minute and then down the next. You've got a tremendous tool here. Tremendous tool. The key is versatility. Now, you must let your voice say and show what you feel. Passion. Passion? That's a bad word for attorneys, right? It's not. If you feel passion, show it. People need to feel what your case is about. And if you're not interested in your case, if I'm a juror, I'm not going to be interested in it. If you're not passionate, I'm not going to be passionate. If you don't care about my 3 boys that were sitting here trying to get a recovery for what happened with their father, if you don't care about it, then maybe I don't either. But if you not only care and show me why I should care, then I'm going to get on the bus with you. The pitch of your voice. Three terms that deal with voice, and I'm coming to a close here. Pitch is the rising of the musical tone. All right, so pitch would be similar to me simply saying or going up as I did like that. You know what I'm saying? That's pitch. Okay. Rate, the duration of sound. Pitch, for example. Let me do pitch again. That is an unbelievable dress you have on. Duration of sound, which is rate. That is an unbelievable dress you have on. Volume. That's an unbelievable dress you have on. Okay? 3 different parts of speech. You've got to regulate all of them naturally. You have a range of talents in your voice, and just in my closing. You have a range of talent in your voice, you have a range of talent in your presentation, you have a range of talent in your intellect, you have a range of talent in your ability to present stories. All of you can do this. This is the way that you talk to your friends. This is the way that you convey information to your children, to your mothers, and to your fathers. I'm suggesting that you should not leave it outside of the courtroom, but that you should incorporate it into all of your presentations. Make people feel. Advocacy is a personal thing. Let it be personal. Let it be that. Now, you can't be somebody else, but you can tell a story like you can. All right? And you can get better at the way you tell a story. You've got to feel whatever you have inside of you. There's nothing wrong with feeling the fire, whether it's for justice or if it's just for winning. Feeling fire is good. There is an old Chinese proverb, and it goes something like this. It goes, tell me, and I'll forget. Show me, and I may remember. but involve me, and I will understand for life. Strive for understanding from your jury at all times. For goodness sake, be honest with them. And that's all I have for you this afternoon. That's almost all I have. I just fooled you.
Questions?
How much time do I have?
You've got 15 minutes.
Okay, good. Last page of your handout. I know most of you know the story of Little Red Riding Hood by heart, don't you? Anyone here not familiar with that? Of course not. Now, I'd like a volunteer. Young lady, would you volunteer first, please? Actually, it's not volunteering because I'm forcing you to come up. Yes, come up and bring your storyline. What I'd like for you to do is we've talked a little bit about stories and we've talked about descriptive words, how stories are told, how to best tell a story, how to break things down, deconstructing language, language with color, descriptive words, and things of that nature. I'd like for you to tell your jurors here, all 40 of them, the story of Little Red Riding Hood. We have a story tree here. Basically, the way it works is that each of these is the sequence in which it happens. Just give us sequence, scene, up to scene 2. The introduction and the beginning of scene 2 would be fine. Be as descriptive as you can, and just tell it the way you'd like.
A long time ago.
Well, let me answer. Hold on. Can everyone hear?
Yes? Everyone can hear me?
Okay. Sure.
A long time ago, in a faraway land, there was a young girl by the name of Little Red Riding Hood. She was about 5 years old, very curious little girl, always wandering off on her own. And on this particular day, her mother gave her an assignment to go and visit her grandmother and to carry a bag of 12 red apples. Little Red Riding Hood was very excited about this prospect. It was a beautiful summer day. All the flowers had bloomed for the year, and this was her first trip out on her own through the woods, so she was very excited about going on this trip on her own. She headed out at about 9 o'clock in the morning, and as she was walking down the path, she saw a fork in the road. And her first thought was, I wonder where that other path will take me. But as soon as she started to head down that path, she started to remember her mother said to her again and again, Little Red Riding Hood, stay on the main path, do not go off the path. But then she started to think, well, maybe my mother didn't know that there was this side path, so let me just try out this side path. I'm sure it'll still take me to my grandmother's house. And besides, on that side path, there were some beautiful tulips up the way. And she loved tulips, so she thought, well, let me go just pick some tulips and see where it takes me. So she goes off the path, and as she's walking down the path, she bumps into 2 young kids, and they're alone as well. And she thinks, well, this is interesting. So she stops and she asks them, you know, how are you doing and how was your day? And then she recalls her mother saying, listen, do not talk to strangers. Whatever you do not talk to strangers. So she kind of takes that conversation to a close fairly immediately and says, okay, let me continue on my way and let me see if I can't find my grandmother's house. All of a sudden, she comes upon a big bad wolf. This wolf approaches Little Red Riding Hood. He's twice her size. He's got a beautiful color about him, but immediately he opens his mouth, and Little Red Riding Hood sees these long 2-inch teeth, and she sees saliva drooping down the side of his mouth, and she gets a little scared. But because the wolf has got such a beautiful color, a mane to it, and reminds her of a dog that she has at home, she decides to follow the wolf out of curiosity to see where it would lead her. And besides, she was a little bit lost, and she wasn't sure if the path would actually lead her to her grandmother's house.
Okay. Thank you.
Is that it? Okay.
Thank you. Give her a hand. Now, Two things. I don't think you would have been as descriptive in telling the story of Little Red Riding Hood if we hadn't gone through what we went through before. But description adds something. I mean, you know, when you start to talk about saliva coming out of the wolf's mouth, I was like, because I saw that, you know. And part of the whole thing is being able to paint a picture that we all can see. The other part of the exercise is in telling things logically and sequentially in terms of a story. And I would simply just add this. Anytime that you have the opportunity to engage in storytelling, whether it be to your friends, whether it be to your significant other, whether it be to your children, use that opportunity. It'll do two things. Number one, it will greatly increase your skills for storytelling, being able to describe, being able to lay things out chronologically and sequentially and in order. But it'll also increase whatever relationship you have with those other people because you'll end up talking a lot more. So I would urge all of you to begin to think in terms of stories. At the end of the day, this is one of the things that I started to do when I first started in storytelling. I actually have been involved in storytelling exploits at storytelling classes and things of that nature, is that at the end of the day, you pick the most important story or the most significant story about what your day is about and tell it. You know, guess what happened to me today? Funny thing happened when I went to the office. I saw such and such a thing. And you know what he was thinking? He was so upset because his family had been left out last night. The heater went out. I said, how could such a thing happen? Well, apparently he wasn't able to pay his gas bill. Well, why not? We all make the same money. Well, John didn't get, and once you begin to do that, you begin to explore setups in stories and how to tell stories in the most appealing fashion. And so if nothing else in terms of a message today, I hope you go away with the message that storytelling is incredibly important. Take a look at that article we talked about from the beginning. Compelling, seductive stories are where it's at. Any questions on anything? Okay. Oh, go ahead.
Different theories on how you should relate to a jury. And you said earlier, you know, the lowest common denominator, sort of put yourself where they are so everybody understands what you're talking about. It goes to be qualified. You found that?
Not really. I mean, I haven't really found that, and let me qualify by saying this. I don't necessarily believe in putting yourself where they are. I believe in using language that everyone can understand and telling stories that everyone can understand, making things more understandable. One thing about it, if you begin to try cases in different jurisdictions, you'll learn that you cannot put yourself in the shoes of every jury, and you are insincere and will be found as insincere if you try to do that. I mean, I have gone from one vicinage to another, and, you know, you can't try to, it's not a when in Rome, do as the Romans do type of situation. You have to be yourself. But even in being in yourself, you can relate your stories. And it's the substance of the story and the theme of the story that carries over to the group, not necessarily you as a teller, but if it makes sense as a story. That's the really, really important thing, a seductive, compelling story.
For instance, you know, I'm a taxpayer, you're a taxpayer, we're all taxpayers, or I've been in that situation and I've maybe driven a little faster than I should have, and I'm sure some of you may have as well. That kind of thing.
Sometimes, depending on the jurisdiction, you're not allowed to do that sometimes, because you're not allowed to personally inject yourself into a case, you know, only to a certain extent you could take that type of license. But you can do that with your jurors. The same thing that you just said is, I've been there. You can certainly just say that many of you have been in that situation, you know, without personalizing it. You know, a number of people have been in that situation. That's not a unique situation. Many people drive over the speed limit. Is that so unusual? And if I had a nickel for every time I have seen people drive over the speed limit, that type of thing. Anyone else? Yes, ma'am. You know, that's interesting. I think that my starting point for all this is an open face. All right, which is the face that conveys information. It conveys an open disposition that I'm ready to impart information, that we're ready to get to business here and we're ready to move forward. Unless something changes, unless another emotion enters into, unless you have a witness who's obviously lying and you have an incredulous face or whatever else it is like that, you're always safest with an open face, because an open face is not a smiling face. What it does is it simply signals that you're ready to do business. And even in dealing with situations that may be somewhat sad, an open face can be appropriate, because that's, go ahead. No, actually, no, that's not what if I said that, that's not what I meant. What I mean is you cannot, I think I was talking about maintaining the same disposition throughout a case. There will always be episodes within a case where you can be solemn, angry, or whatever else. The case in New Jersey that was just recently tried, the Temendekwas case, which involved Megan, and Megan's law came from that whole thing. The atmosphere during the entire trial of that case was incredibly tense. I mean, not once did, as I've seen in many homicide cases, did there come a time for lighthearted laughter. You have to gauge it by how it goes. Now, when you're dealing with a fraud case, you're generally, I think in large part, you're going to be talking about putting in technical proofs. And technical proof work, I don't think necessarily in all cases requires you to have an angry disposition or anything else like that. I think there may be times when you're talking about certain witnesses who may have either lied or have had a bad motive, like remember Bob Johnson? And we want to convey something about that particular witness. There's a time to present that face. But the only time I think that you can have that throughout is when you're compelled to in something like the case I described, the Megan case, where you've got to be dour the whole time. Yes?
In various jury trials that you've seen, have you seen any consistency in the way that jurors will look at the government's case and the government's attorney when they sit in the box the first time they start hearing the evidence?
Realistically, nothing that I could actually quantify or would want to actually qualify. I get the feeling, though, that jurors coming into cases expect more from government attorneys. I just have that feeling. I can't tell you where that comes from, but I just get that impression personally. I know clearly they expect a higher degree of professionalism, because when studies have shown that when people malign lawyers, they're not talking about government lawyers, they're not talking about prosecutors. They're talking about the sleazy defense attorney. The guy, and even in that mold, most of the time they're talking about either the personal injury attorney or the ambulance chaser or whatever else. Okay. Thank you.
Thank you very much.